Hi friends, this is CMA Deepika Bhugra Prasad, Insolvency Professional. The insolvency regime in India has seen several ups and downs ever since its inception. And the code IBC 2016 has gained richness, depth, and maturity with every transaction, especially the judgments delivered by our courts, which have strengthened its processes in sync with the emerging market realities. So, friends, I welcome you to Insolvency Insights, a snippet series curated by me to delve into important judicial pronouncements under the Act IBC 2016 and to navigate through the intricacies of the proceedings under these judgments. So, let us today discuss one important case. So, friends, this is the case of Global Credit Capital Limited and another versus Sach Marketing Private Limited and another, which was decided on the 25th of April 2024 by the Honorable Supreme Court of India. So, in a landmark decision, the Honorable Supreme Court issued a ruling delineating the characterization of debts within the framework of operational and financial debts under the Insolvency and Bankruptcy Code 2016. The case of Global Credit Capital Limited and another versus Sach Marketing Private Limited and another offers critical insights into the understanding of debt classification, particularly concerning the nexus between the debt and services rendered. The Honorable Supreme Court upheld the judgment and order of NCLAT New Delhi bench dated 7th of October 2021, which is the impugned order by which Sach Marketing Private Limited was held to be a financial creditor of Mount Shivalik Industries Limited, the corporate debtor, in CIRP under the provisions of the IBC 2016. Such claim against the CD arose in respect of a security deposit provided by Sach to the CD under an agreement. Now, NCLAT held that Sach was a financial creditor for the purposes of IBC, inasmuch as they had provided loans to the CD. The successful resolution applicant challenged NCLAT's judgments and orders before the Honorable Supreme Court. Now, let us see the factual background of the case. Now, Sach and the CD entered into two agreements in 2014 and 2015, by which CD appointed Sach as a sales promoter to promote the beer manufactured at its factory for a period of 12 months. Under the terms of the agreements, Sach was liable to deposit certain amounts with the CD as security deposits, which were repayable with interest by the CD. In 2018, CIRP was initiated against the corporate debtor, and Sach filed a claim as a financial creditor, claiming security deposit and interest as a financial debt, which was rejected by the IRP on the grounds that Sach could not be treated as a financial creditor. As against this, Sach preferred an application before the Honorable NCLT, seeking a direction to admit its claim of rupees 1.41 crore as a financial creditor. The NCLT dismissed Sach's application and Sach appealed to the NCLAT. By virtue of the impugned order, the NCLAT allowed the appeal, holding that Sach was a financial creditor of the CD and not an operational creditor. NCLAT relied upon the interpretation of financial debt in Orator Marketing Private Limited versus Samtex Designs Private Limited, where the Honorable Supreme Court held that a transaction which has the commercial effect of a borrowing falls within the definition of financial debt under Section 5, subsection 8F of IBC. As against the impugned order, the present appeal came to be filed before the Supreme Court by the successful resolution applicant. Now let us see the issues before the Honorable Supreme Court. Now the sole issue for consideration before the Supreme Court was whether the amounts paid by such to the corporate debtor as a security deposit under the agreements could be treated as financial debt within the meaning of Section 5, subsection 8F of the IBC. It was contended by the appellant before the SC that the agreements were service agreements, which indicated that the CD had appointed such to promote the beer manufactured by it. And this was a service rendered by such. And therefore, the amounts paid towards security deposit were liable to be treated as an operational debt under Section 5, subsection 21 of the IBC, and not as a financial debt. Further, the security deposit paid by such under the agreements was merely a condition precedent to be satisfied for its appointment as a sales promoter of the corporate debtor, and that this could not be equated to money disbursed to the CD as a financial debt. Therefore, these amounts would not satisfy the definition of a financial debt under Section 5, subsection 8 of the IBC. Further, that merely because the amounts paid towards security deposit were acknowledged by the CD in its books and interest was payable towards the said amounts would not be sufficient to treat the said amounts as a financial debt under the IBC. As against this, such submitted that the agreements did not contain any provision for deductions or forfeiture of the security deposits paid by such, and that the amounts paid towards the said deposits were liable to be returned with interest. Therefore, from a complete consideration of the facts and considering the true nature of the agreements, the Honorable NCLAT was right to hold the amounts paid towards the security deposit under the agreements as a financial debt, since all the three criterias, namely disbursal, time value of money, and commercial effect of a borrowing, as specified under Section 5, subsection 8 of the IBC, were satisfied. Now let us see the verdict of the Honorable Supreme Court. The SC examined Section 3, subsection 6 and Section 3, subsection 11 of the IBC, which define claim and debt respectively, holding that a claim is a right to receive a payment, whether under law or equity, or arising as a remedy for breach of contract, and a debt, whether operational or financial, could only arise in respect of a claim under Section 3, subsection 6. The SC also examined Section 5, subsection 8 of IBC, which defined the term financial debt, holding that the categories enlisted under subclauses A to I of Section 5, subsection 8 must satisfy the test of being a debt, along with interest, if any, which is disbursed against the consideration for time value of money. The court specifically emphasized Section 5, subsection 8F, which pertains to an amount raised under transaction which has the commercial effect of borrowing. The SC clarified that the debt arising out of a written agreement or an arrangement providing for rendering of services, which would be an operational debt, only if the claim made in respect of the debt has some connection or nexus with the service rendered under the agreement. Therefore, merely because the written agreement is an agreement providing for rendering of services would not always lead to a conclusion that the debt arising out of the said agreement was an operational debt, but the real nature of the transaction would have to be determined. Further, the agreements in question did not contemplate forfeiture of security deposit paid by such, nor was the security deposit linked to the performance of the other conditions of the agreements or the service rendered by such under the agreements. Therefore, the CD was liable to refund the security deposit amount with interest to Sach without any right of forfeiture, and Sach's right to seek a refund of the security deposit would amount to a claim within the meaning of Section 3, subsection 6 of the IBC. Therefore, the SC held that the said amounts could not be said to be an operational debt, since a plain reading of Section 5, subsection 21, which defines operational debt, indicates that it pertains to a claim arising in respect of the provision for goods and services. So, friends, we conclude that the definition of a financial debt under Section 5, subsection 8F includes any amount raised under any other transaction having the commercial effect of a borrowing. And the definition of transaction in Section 3, subsection 33 of the IBC includes arrangements for transfer of assets, funds, goods from or to the CD. Further, the amounts paid towards the security deposit had been treated by the CD as long-term loans and advances in its statements. Therefore, the transaction between Sach and the CD fell within the definition of transaction under Section 3, subsection 33, as there was a written agreement for the transfer of funds to the CD, and the amounts raised under the two agreements by way of security deposit had the commercial effect of a borrowing. On this basis, the SC upheld the impugned order and held that the CD treated the said amounts as borrowings from Sach, and consequently, Sach was a financial creditor of the CD. So, friends, we see that the courts are actually going into the operational details of the companies so that a justice can be done for each stakeholder under the code IBC 2016. So, friends, I trust that you find this both engaging as well as enlightening. So, for further details into such judicial pronouncements under the Act IBC 2016, please like this video and subscribe to my YouTube channel. So, thank you very much for being with me here today. This is Deepika B. Prasad signing off, and we'll catch you in the next case. Thank you.